Okay, I'm going to call this meeting to order. We have on the agenda today House Bill 524, and I think Representative Brockway, there he is. Come on down. Why don't you go ahead and present your bill? Why don't you come on up front here? We'll recognize you for the purpose of presenting the bill. All right, which one? Where is this? Check it now.
How's that?
I think it's on.
We got it. All right. You ready, sir?
Yes, sir.
Great. Well, thank you, Mr. Chairman, and ladies and gentlemen of the committee. I appreciate you being here today and giving me this opportunity to present to you House Bill 524. It seeks to do one very simple thing, and that is to allow adult adoptees to obtain a copy of their original birth certificate. In the adoption process, when a person is adopted as a child or any other method, their original birth certificate is canceled and a new birth certificate is issued with the names of the adopted parents on it. That presents something that we hope that this bill will address, and we'd love to discuss with you further as we move along today. That creates sort of a vacuum or a walls off the information about something that I think is very, very critical, and something that folks like me who are not adopted sort of take for granted. And that's knowing as much as you possibly can about where you came from and about your past. By separating that and sealing that original birth certificate, it sort of keeps a key piece of information away from the person who has been adopted. Also in the bill, I'll describe very quickly, and then we'll get on to some of why I brought this bill to you here today. The second section of the bill deals with the creation of a contact preference form, and that allows the birth mother or the birth father or both to file a form and express their wishes as to whether, when they give up this child to adoption, whether they'd like to be contacted at some point in the future. It gives those birth parents the flexibility. They can change their mind as often as they want, depending upon what their desires are at that time, and the department would provide to, if an adult adoptee requests a copy of the birth certificate, they would be presented also a copy of this contact form, and they would know the wishes of their birth parents, whether they want to be contacted or not. Now, a couple of things to understand about how things work here in Georgia. As I mentioned, once an adoption takes place, the original birth certificate is canceled and put in file. And the only way for a person to obtain that is to go to court and to try to present to a judge the case as to why they should be allowed to have that access to that original birth certificate. And what's interesting to note is this also involves cases where you may have a blended family. Like in my own case, my father, and when I was 6 years old, my father and my birth mother divorced. And then a few years later they got married, and so I had a stepbrother. And at some point in time, my father decided to adopt my stepbrother. Even in that situation, when my brother knew his birth father and had contact with his birth father, he still could not have, because of Georgia law, still could not have a copy of his original birth certificate. So this does apply to a lot of cases, and some things that you may not think about that arise that have nothing to do really with what you might think of a situation where a birth mother might not want to ever have contact. So and I'll also remind you that last year you folks debated, had a good healthy debate, and we passed a bill by Representative Oliver that dealt with post-adoption agreements, contact agreements. And if you'll remember during that debate, it was pointed out, and we've got studies that back this up, the trend in adoptions is to make them as open as possible. Studies have found, research has found that it is better for all parties involved, especially the children and especially adults who were adopted as children, for the adoption to be open. And that is certainly the trend, and the bill that we passed last year that Representative Oliver had helped move that moved us in that direction. The negative stigma that used to be attached to the whole adoption process just doesn't exist anymore, in my view. And we ought to make sure that our laws change with the times. We ought to update our laws to give as much openness and access as to adopted parents and adopted people as we possibly can. Ladies and gentlemen, that's the nuts and bolts of the bill. I would love your favorable consideration. I'll be happy to answer any questions that you may have.
Thank you, Mr. Brockway. We have a few questions.
Yes, sir.
Number 19, who is that? Sorry. Representative Coomer.
Thank you, Mr. Chairman. Mr. Brockway, I have a question about one particular line, line 57. It says that, and this is the section providing that an adopted person who's deceased may have their living relatives acquire a copy of their original birth certificate. And in line 57, you say that those people include any parent, sibling, or descendant of the person. And my question is the any parent intended to include both the birth parent and the adoptive parents who would be able to access the original birth certificate, or should that be limited in some way? What's the purpose there?
Well, I think that the purpose is to, for all the same reasons that an adopted person may want to obtain a copy of the original birth certificate, it's possible that in many cases, it may be the case that their family, their descendants, their spouse may want to obtain that, or their adoptive parents may want to obtain that as well. So I think that's trying to open it up as broadly as possible. By reading this, I would assume that it includes the birth parents, but I would also presumably it's possible that they have a copy of that already. So
I guess it kind of becomes a policy question of whether we want the policy to be birth parents should have the same access to the birth records of the child they gave up for adoption, even though I think the current status of the law is they basically give up that access when they terminate their parental rights through the adoption process.
The records are sealed. Yeah, that's my understanding. Yeah.
Would you be open to clarifying that to include just the adoptive parents having access, as opposed to the adoptive and the birth parents having access?
I'd be well. I mean, I think we're open to that. I think, my question is why would we want to do that? If we're allowing, sort of treating people who are in the same situation differently, because the birth parents are still, they're still there. They're still part of this process. So to deny them the ability to obtain it without going to court, but yet give that access to adoptive parents or to adult adoptees or adoptees, it doesn't seem to make sense to me why we want to limit that. If we're opening it up to all the parties involved in this situation, then we ought to open it up to all of them.
Well, I guess the difference in my mind is that the birth parents are essentially agreeing to, as a matter of law, not be the parents of this child any longer. They're giving up all of that bundle of rights that are parental rights when they give up the child for adoption. I guess the policy would be that you don't want to create a situation where adoptive parents can, down the road, decide they want to be the ones reaching out to try to have contact with that child they give up for adoption. My father-in-law was adopted. He's elected not to find anything out about his birth parents, and that should be his option as the adopted child who was given up. It shouldn't be the right or the option of the parents who gave up the child to then later decide they're going to have the impetus to have contact. I guess that's where I'm coming from.
Well, there's many of the members of this panel are lawyers who are, some of them deal with this on a day-to-day basis. I'm not a lawyer. I get to play one 40 days a year. So the finer points of the law, I'll leave that up to you folks on the committee. I guess I would go back to what I mentioned earlier. The trend in adoptions is, the research that backs this up, is that the more open we can make it, the better. That's better for all involved. So, and it's also, important to point out that obtaining a copy of your canceled original birth certificate is not a legal document. So I don't think that in the situation you mentioned there, and you lawyers can probably answer better than me, if you obtain a copy of your original birth certificate, you're a parent who gave up your child for adoption, and then you decide, I want to get a copy of the original birth certificate. It's not a legal document. It does absolutely nothing. It doesn't give you standing, any more standing than you had the moment before you obtained that document. It's not a legal document. So I don't think that would allow a birth parent who gave up, who relinquished those rights and to raise that child, to come back later and say, I've changed my mind.
Thank you.
Thank you. We have other questions. Representative Wilkerson.
Oops. Am I on? Representative Brockway, I got a question. This is, I guess, an educational experience for me.
Me too.
So if this were to become an effect, if a parent gives their child up and then decides they don't want any further contact for whatever reason it may be, maybe it was a traumatic experience or whatever the situation was that caused them to give this child up for adoption, even though they fill out the preference form, that preference form does not stop that child from contacting the parents. Is that correct?
Yeah, there's no penalties involved in that. And all, we've seen, I mean, the way it exists right now, even if you're an adoptee and you don't have access to your original birth certificate, that you can still find out who your adoptive parents are. That happens. And now in this internet, in this information age, it's happening more and more. Yeah. Folks are bumping into each other on Facebook, saying, "When," and then they find out, "Hey, you're my mom or my dad." This happens. So there is no way to, there is no way to stop it, in my view, completely. There's really no way to provide complete anonymity to the birth parents. We just live in that age now where this stuff's available. So yes, the contact preference form is just stating a preference. Okay, if somebody if an adoptee decides, I'm going to ignore the wishes that are expressed on this form, but they can do that already. They just having that information, I think, is more of a restraint than it would have been before they had that information, because they can still continue to find their birth parents.
One follow-up question, Mr. Chairman. So, but this would basically just legislate that I have that right to find out. I mean, granted, say it's you have a child that says, I have two choices, either terminate this birth or give it up for adoption, and I decide to give it up for adoption because I realize that is a chapter that happened that I will never have to look at again. Is there any concern at all? I mean, you can't say, I don't think you can predict the future, that people will make different choices because of the fact that they no longer have that, at least legislatively, somewhat guarantee that they will, be able to.
We have the benefit of looking at what happened in other states that have done this. There are 10 other states that have done things similar to what we're proposing here. Mm-hmm. In many cases, we've seen the amount of adoptions go up because it's a more open process, and that's healthier. And getting back to the parents, the birth parents who are giving up the child for the adoption, in 5 states that have passed a bill that's extremely, almost word for word what we're trying to do here, 0.7% of the mothers have said, I don't ever want to be contacted. Mm-hmm. So, we're dealing with, yes, we must consider this. We must be wary of this as we move forward with this policy change. But we can look at the experience in other states and see that most mothers end up wanting to be contacted. Mm-hmm. And the incidents where this has caused harm is we can't find it.
Okay. Thank you.
Thanks for the question.
Representative Oliver.
Thank you for bringing this bill.
Yes, ma'am.
It is a policy question, and I'm going to weigh in a little bit on the side of fathers' rights. We have a lot of discussion right now about misidentification of biological fathers in a variety of different settings. And the biological father, whether it's a genealogical search, whether it's a medical search, when he may not be the the child was not a legitimate marriage. In other words, that the child was illegitimate at birth. That's a Georgia term, not a national term. I want to give the policy weight to him. Was he on the birth certificate? Does he want to know that when he should have been with somebody else on the birth certificate? So I think the openness and all the variety of ways that people are valuing openness in support of adoption would probably lead me on the policy question to say any parent.
I would agree.
Thank you, Representative Allen. Representative Bell?
I will answer.
Okay. Thank you. Okay. Representative Quick?
Thank you, Mr. Chairman, and Representative Brockway. First of all, you know, this bill is very commendable in the access and the ease of access to this very important record for those folks who have chosen that route of openness that you talked about. Unfortunately, the bill does not apply only to open adoptions. It applies also to closed adoptions, where the birth mother has chosen not to know, or where that has been the discussion and the agreement, as we talked about last session, between the adoptive parents and their attorney or the folks that they're dealing with, and a closed adoption has been selected. So from my perspective, the policy question is that in Georgia, should a woman who chooses life likewise have a corresponding right to choose anonymity? Does that right to choice include the right to remain anonymous? And this bill does not do that. I wondered if you could speak to that.
Yeah, that is a tough question. It is, you know, at some of these situations, maybe more so in previous generations than in ours today, where women are having babies, you know, without some of the stigma attached that may have been attached in previous years. So, yeah, I don't see how in this information age that we can guarantee anonymity, complete, you know, for forever or for any length of time, really. So I would, you know, and I think we would back it up with the research to say that the more open, the better. I would come down in favor of the openness aspect of it. I understand there are situations where there are closed adoptions, and you know, I'm open to, you know, finding a way to deal with that. I think that, you know, more and more we're finding those cases are rare, and more we're, you know, we've seen these experiences in these other states. That's not the norm, and in fact, it's a very small minority of these sorts of cases. So, yeah, it is a policy question, and it is, you know, we need to consider that. I suppose I would come down in favor of the rights of the adoptee.
Thank you. Okay, we got Representative Sheila Jones.
Yes, I have a question for clarification. Concerning the parents, I think that you said earlier that the parents can sign a statement saying that they want to be notified.
Yes.
But in the summary, I'm reading that if they are over 18 and older, that they can pay a fee and receive a copy of their original birth certificate. So if my thinking is that if you receive both of them, if the parent has signed something that don't want to be notified and the parent's name is on that original birth certificate, can't they be contacted through the original birth certificate with the fee that was paid?
I don't have a copy of that summary, but, you know, to answer your question, you know, we're creating in this bill, we're asking the department to create a contact preference form that would, well, the parent could, either parent could express their preference whether to be contacted at some later date or not. We give them the option to file as many forms as they want. They can change their mind. That's in here to allow them to do that. Now, I guess your question is that if you've got names on the original birth certificate, can't they go ahead and contact them anyway? I think that's always possible, that somebody could ignore the preference expressed on the form. The experience that I've had, this is the third year I've been working on this bill, and the folks that I've met and the people I've talked to, the adoptees understand this is a very sensitive situation. And if someone has expressed, if their birth parents have expressed that they do not want to be contacted, I think 99 times out of 100, the adoptee is going to respect that, simply because you're dealing with a very emotional situation. And the last thing you want to do is proceed forward knowing that you're going to be, that you very well could have your heart broken. And that's the kind of situation we're dealing with. If somebody expresses a wish not to be contacted, I think it's going to be an extremely rare case, and we've seen this in the other states. That just almost never happens. So I think, and I would reiterate, right now there's just no way. There's nothing in our law, and nor do I believe there should there be. There's just nothing that stops somebody from finding their birth parents by any number of means. And this I think this fits in with that. It's happening. It's going to happen, and I think the things we can do to encourage those things to happen in a healthy manner is good public policy.
I'll follow up, if I may. You said that with this information age that we have, you don't see where people can be stopped from finding their birth parents. So why are we including that the birth parents can fill out a notification saying that they don't want to be contacted?
Well, because I think we have to respect their, we have to, as much as we can, respect their wishes. If they don't want to be contacted, I believe they ought to be able to express that desire. Because again, it gets back to you're dealing, everybody involved in this process knows you're dealing with a potentially emotional situation. So I think knowing that ahead of time is very beneficial to the adoptee. They want to know, does my birth mother or father want to meet me? I think that's very valuable information for the adoptee.
Right. Okay.
Representative Sam Watson.
Oh, I'm sorry.
Okay. Representative Keisha Waits.
I got the question answered.
Okay. All right. Representative Braddock.
So if the paperwork where they do that designation on whether they want to be contacted, so what happens for everything in the past? They don't go back and contact them to state their preference, do they, for past adoptions?
Well, it's my hope and my expectation is that the department will make this publicly available. How far and wide that information is disseminated, I don't know.
Okay, so they would just initiate it. The parent would initiate. Okay, thank you.
And moving forward, as adoptions take place, attorneys who had handled this will let the birth parents know about the form.
Mm-hmm.
Chair recognizes Representative Sharper.
Okay, thank you, Chairman. I was just wondering, is there any data that really shows the demands and how much the adults as well as any parents or anything like that are requesting this information? I think that would be helpful to know the data.
I don't know how many, as it currently stands in Georgia law, you have to go to court.
Mm-hmm.
I don't know how many court cases have taken place, but I think you look around the room. We have a lot of folks here who are in this situation and have come down here to take their time to express their desire that they want this information. The other states we've seen, it's in the thousands that take place every year, and that's kind of in keeping with the amount of adoptions that take place.
Okay, thank you. Chairman, is it okay for some to stand that are really here, really requesting this time after time? Is it okay for them to stand? Can I get a good feel of that?
Sure.
How many of you guys
If
are
you're
here, like, go ahead, Chairman.
If you're in favor of the bill, please stand.
Okay.
Okay. All right. Thank you. And if you're not in favor of the bill, please stand. If you're against the bill, I guess I should say that. Okay.
Okay, thank you.
All right. Thank you. Representative Bell?
Hey, Buzz.
Hey.
Question for you. So when the birth parents fill out this form to say either they do or don't want to be contacted, are they advised at that point that it's really not worth the paper that it's written on, that the adoptive parent, that the adoptee, that they'll still get the information? Are they informed of that up front, or how's that play out on the form?
Well, I guess I would disagree with your characterization. I don't think that it's
That's fine.
It's worth a lot. I don't think it's not worth bothering with. I think it's a very, very important document. I think the adoptee needs to know if their birth parents want to hear from them or not. I think that's very valuable. I would think that as attorneys practice this, they're going to advise their clients as best they can on each situation is individual and different. So I think the attorneys and probably the attorneys on this committee who deal with these things are going. They can probably answer. I've never done that. I'm not an attorney. They can tell you about the unique nature and situation of each case that they're dealing with, and so I think they're going to advise their client the best way they can in each of those individual situations. So,
and their client would be the adopted child?
No,
when you say their client,
the parent giving up the child for adoption.
Okay, just want to be sure. But if they're signing this particular form, whether they say they want to be contacted or not, just for clarification, do they know that will they be informed or told, or will the form state that by signing this does not guarantee that your child that you are giving up for adoption won't contact you?
We leave that up to the department to put on the form.
Okay.
I think a good attorney would explain exactly what this means and what it does.
Okay, that was my point.
And again, I'll get back to in the states that have the states that have passed this, 5 in particular that have a contact preference form. We're not seeing problems. We're seeing what we want, which is a fostering of a healthy environment where the adoptees and the adopted parents are finding this sort of thing very beneficial.
I'm with you.
Yes,
I
ma'am.
just want to make sure that the birth parents, what's going to happen with them, and that they have a full understanding of
Yes,
that.
ma'am. Thank you for the question.
Representative Welch?
Mr. Chairman, thank you. Representative Brockway, thank you for bringing the bill. I have a few amendments that I would like to point out for the bill, and one of which we're having some difficulty trying to fashion.
Okay.
And so the more difficult amendment is dealing with the issue of the form allows for, once you fill out the contact form, it contains a statement in there that the form will include the contact information for the birth parent. If you select that you do not want to be contacted, which is subpart C, line 84, if you select that, then the way this is worded, it suggests that the contact information will still be on the form, even though you've selected no. And then if you read down on lines 93 to 96, that mandates that the state register must produce the form if requested. So in a way, you're kind of defeating the purpose of allowing for anonymity, at least with respect to contact, by compelling the release of a form that contains the contact information on it, even though you selected not to provide it. So to me, there's a problem in that. We're trying to fashion a solution to that problem, but I think that's going to take a little bit more time than we're going to have today. So the other aspect is I know that a lot of people have come today to speak, and if we could, and I'd like for one to try to hear from some of those folks today, and then if we have more hearings, that perhaps they can come back.
Thanks, sir. Representative Kendrick?
Thank you, Mr. Chairman. Hi, Buzz. I have a comment and a question. I think I told maybe you and other members that are sitting out there that my mom was actually adopted, so this comes really close to home for me. But I don't know if you know the answer to this, but do you know the original reason why the legislature or the court decided to seal the documents from the birth parents in the first place? Was it because of people contacting the birth parents, or what was the original reason?
No, it was my understanding, and like you have only been in the legislature now for 4 years, but my understanding is it was a different time and a different era when adoption was looked at in a very, very different way than it is today. And you know, quite frankly, young women who may have been pregnant out of wedlock were sort of squirreled away, and oftentimes didn't really have a say so in what happened. So it's really, from my understanding, that's the genesis of it, to try to, you know, reflected the times. And we live in different times now where there is no, you know, adoption is encouraged, and it's a very, very special and meaningful thing. So I think, you know, this, as I mentioned earlier, I think we need to, our laws need to change with the times, especially in relation to that particular issue.
Okay. I don't think I have anybody else who has a question that's, oh, excuse me. Gotcha. I'm sorry, Mr. Holcomb. Representative Holcomb.
Thank you, Mr. Chairman. I have two questions. The first is to clarify with respect to Representative Quick's question about anonymity. It seems that there would be anonymity for the birth parents until at least age 18 or longer, correct?
Yes. Okay.
The second question that I have is with respect to the contact preference form. It seems that that should go to everybody. In line 69, it says upon request, and I know that there's issues with prior adoptions. So it seems like as just a matter of course that should be provided. And the other question that I have is, what would the inference be if there was no contact preference form on file?
Well, to answer your first question about, you know, disseminating it, I think the reason we wrote this is modeled after what they did in Oregon. So my understanding is, my perception of this is that you know, the form is there. You know, the original birth certificate is there, but it's not accessed unless it's requested. And so going along with that, the contact preference form is sort of in the same place. So if you're an adult adoptee, you turn 18, you say, I want a copy of my original birth certificate, you're given that, and you're given this contact preference form at the same time. So I think that's kind of why it's written the way it's written. You know, we don't have to do it that way. We can do something different if we want. But I think it's just that this is meant to accompany the original birth certificate. So I think that's why line 69 and 70 are the way it is. That the form is disseminated when it's requested, along with the original birth certificate. Your second question
is, if there isn't a contact preference on file, what would the inference be?
I don't, you know, that's a good question. I think it's.
That's why I asked it.
Yeah, it's, you know, it gets back to the, you know, the emotional nature of this whole process, and I think we would leave that up to the adult adoptee to interpret that how they want. You know, it's, you know, if you're an adopted person trying to find out who your birth parents are, I think, you know, you've got a whole range of emotions that you're dealing with. And that would probably, if I were in that situation and there were no contact preference form, I'd probably be a little disappointed, because that's a very important question that's left unanswered.
Thank you. I support the bill. Appreciate it.
Thanks, sir.
Thanks, sir. At this time, I want to cut off the questions from representatives. We have about 10 minutes to take comment from the the folks who have signed up. And I'd like to recognize Leslie McKinnon. And you're with Georgia Support Open Records?
Yes, Gear.
Gear.
Thank you. And I do hope you'll ask me questions too, because I am a birth mother. And if I'd come to talk to you 20 years ago, 30 years ago, I couldn't have looked you in the eye because of the shame that I lived with. And I'm also a social worker, and I work in this field. And what's changing in adoption about opening things and getting rid of secrets and shame is making people very healthy. I work with birth mothers today. I work with adult adoptees, children, adoptive parents. And the more we open up, the more we get healthy, and things are working so much better. I can give you some of the numbers that you were asking about if you want them, but I can tell you I was promised nothing, absolutely nothing. And Elizabeth Samuels, who's an attorney and teaches at the University of Baltimore, I brought some copies of her paper if you're interested, because she's very eloquent. She did a research study. Birth mothers were not promised anything. The only confidentiality I had was while I was in the maternity home. Then, yes. So this has been, for the people that were on the opposite side of this fence, this has been a great myth that has been just going and created and got a life of its own. The reason I'm here today is my sons found me. It changed my life. It changed their lives. It helped me to specialize in this career because I could come out into the open and I can face you and look at you, and I'm proud of who I am and the work I do. And I do not believe that we need to treat these adult adoptees like they're children any longer. That birth certificate is the first thing that's created about each one of us, and what they have and how they say it is, mine's a lie. Mine says that the parents who raised me, who I love, but who were not able to have children, gave birth to me. Now, what's wrong in that picture? Okay, so could I just have the truth? And the truth is what sets us all free. Somebody real important said that just a couple of days ago. So I think that we should support this. I think we've been coming to you for a long time. I am so grateful to each and every one of you for hearing us and listening to us and letting this come before you. And I can tell you that in the states where it's been passed, my son is from Alabama, and it's been open in Alabama since 2000. He found me before that, by the way. Anybody can find anybody. I see 11-year-olds that have found their birth parents on Facebook. So hanging out with this, we can keep them from doing it, is absurd. We cannot keep anybody from doing anything. If you don't want contact, then of course you can say, I don't want contact. And if the adoptee contacts you anyway, you say, I would rather not have contact. Working with these people, I can tell you something. If a parent says they don't want contact, they're not going to do anything. It's rejection a second time. That's about as far as most people can go. But if for some reason you had that one odd person who kept on coming, do whatever you would do in any other situation to say, please, leave me alone, okay? So if you have any questions, I'm very open to them.
Thank you, Ms. McKinnon. I don't have any questions. I'm sorry. I do have one. Sheila Jones, Representative Jones.
Thank you. Leslie, I have a question. If someone, an adoptee, fills out a form and submits the form and the parent does not say yes or no, just ignores the form, what happens then?
I'm glad you asked me, because I heard you ask that, or somebody did, and I think, in all honesty, the adopted individual would be hopeful. No news is better than a no. So they might then come forward and try to make contact. But this really isn't about contact, because this is about adopted adults having a right to what is legally theirs. There have been people who have been, since 9/11 stopped in airports because there's a great length of time in between when the adoption occurred and when it was finalized, and that pulls a red flag. These people have difficulties by not having their birth certificates. But did I answer your question? I feel like it would give them hope.
I hear your statement about it's their right, but if I'm the parent of the child,
yes,
and I do not want to be contacted at all, yes, even though they submit the form to me, I just throw the form away because I don't want them to see my name or contact me at all, and I don't want to have to fill out the form, which will permit me to put my name or whatever the form is going to have on it. But if I just ignore the form at all, will that automatically allow them to contact, get their birth certificate, which will have my name and information on it?
They would have then better access, a better way to find you, and they might in fact contact you after you internally know you didn't want it. But if you hadn't said it, and they don't know that, I would imagine there'd be a good chance they'd reach out. And what they usually do is write a letter or make a phone call after they've sweat bullets and gone through all kinds of emotional pain. This is the most emotional journey you can imagine. It changes people's lives. And then I think if you're that birth mother who said, I really just can't go there, and it's usually because the pain is so great, that's what you say when the person calls. It's a free country. You just say, I'd rather not. I'm sorry. What I always encourage mothers to do is give medical information, because that's imperative. So at least say who you are and give medical information, and if you can't go any further, fine. I personally, I've been at this 43 years. I've never met a woman who said no, personally.
Thank you. At this time, I'm going to cut off the comment from the public. We're going to put this bill in the Welch subcommittee, and we'll have an announcement about when the subcommittee hearing is going to be had on this. And I apologize to those of you who come to comment today. There was some meetings scheduled after we had set this one that required lots of us to be away from here. But Andy Welch, this is the subcommittee chairman right here. He'll have the hearing, and we'll get you a notice out. You'll hear it from Ms. McCooley in my office, and we'll take care of that way. I would like to recognize Commissioner Avery Niles. Very much appreciate you being here. Thank you, sir. That's a real leader who's standing in the breach and doing a great job at juvenile justice. Thank you for being here. It's great to have you here, sir. And I also want to recognize the newest member of the team, Chuck Estration. Welcome. Glad to have you here, and look forward to working with you.